Welcome to this question and answer session with Bruce Thornton, independent consultant and trainer. Bruce developed the risk model several years ago with David Paul of Gwynedd Council. Bruce has introduced the risk model to authorities across Wales and England over the last 10 years. In this conversation, we focus on the word likelihood and how case law can help us understand how to interpret it in practice. Bruce: we often talk about significance as an important legal component in these matters. What about likelihood?
I think there are at least three of these components. Firstly, establishing harm, then its significance, and of course, likelihood. So when we look at significant harm, we're either looking at significant harm that has occurred, where you have therefore evidence, or significant harm that is likely to occur in the future. And of course, you also have significant harm that has taken place and is likely to continue. When we look at this in the Children Act 1989, we see likelihood occurring in several key sections. For example, Section 47 places the duty on local authorities to make inquiries into child abuse if there is reasonable cause to suspect that a child who lives or is found in their area is suffering or is likely to suffer significant harm. And then, when the court is considering making a supervision or a care order, the threshold in Section 31(2) states that the court can make an order if they are satisfied that the child is suffering significant harm or is likely to suffer significant harm. As with the other key components, we turn to case law to help us understand how the courts interpret the words likely and likelihood. And this in turn helps us work out how we should be practicing within the spirit of legislation in our day-to-day work. That is, we can defend it as an appropriate use of our legal authority with a view to knowing how the court interpret these. However, we also need to remember that some of these deliberations can only be resolved by the court. Practitioners do need a reference framework of case law to clarify interpretation, but they can't second guess. What is hard is that most child protection work exists outside the court arena and therefore is beyond such scrutiny. So we'll explore this with some hesitation. These things are so nuanced. This is about the prediction of future harm, and we know two things. Firstly, in child protection, you can't be definite or absolute that something will happen. Neither can you say something will never happen. It's a prediction. So likelihood exists somewhere between these. The argument in case law is where this lies and what evidence indicates that fact. Case law tells us that likelihood means no more than a real possibility that it will occur. Don't think of likelihood as more likely than not. You should think of likelihood as being a real possibility that something will happen. Don't think of it as being only marginally in favour, something like 51%. No, it needs to be stronger than this, a real possibility. Case law adds that real possibility is one that cannot sensibly be ignored, given the nature and gravity of the feared future harm, and that real possibility needs to be based on evidence, facts or judgments based on the balance of probabilities. So your judgment needs to be evidenced.
There are very different types of harm. Does the type of harm have any bearing on likelihood?
Yes, it does. Case law in particular focuses on psychological or emotional harm as a contrast to other types of harm such as abuse or neglect. If likelihood is only about future prediction, what I mean is that this feared emotional harm hasn't yet happened or been proved in the past. Then courts have considered this. Some of their comments are that psychological harm often takes a long time to materialise, and the question is how guaranteed you can be that this will actually happen in the future. You can't, and children are resilient. Some cope with a lot of adversity without showing these effects. So you can make an argument that a parent's behaviour in the future will result in the predicted harm, to such a degree that you want the court, on behalf of the state, to take steps to consider interfering with the autonomy of parents to bring up the children in the way that they choose. It's quite a tough call to take, isn't it? There are other observations when considering the likelihood of psychological harm. Ask yourself, why now? What is it in the argument of likelihood of such harm that meant it was so urgent to have to do something now rather than wait and see if the real possibility becomes more obvious? We see an interesting argument developed between likelihood and severity. The more serious the harm, the less likely it needed to be to meet the test. In contrast, if harm wasn't serious, it had to be very likely to happen.
So you've mentioned a few things. There is something here about psychological harm, how difficult it is to predict, and the seriousness of the harm needs to be factored in. Anything more definite?
I think in these considerations, well, they do sound quite vague, don't they? So, what is clear, what we need to remember is that it has to be a real possibility. Serious predicted harm can be less likely to happen to pass the threshold. You ask yourself, how definite can I be? Do I have any evidence for the prediction I am making? Does this have to happen now? Can I justify this interference in private life of families now? Can we wait? If not, why not? I think they make a good start. But if you want something evidence-based, there is research that has driven some predictive indicators. Some research is quoted in the 2014 Department of Health research paper on parental capacity to change. The research indicates key factors linked to future harm being more likely. And of these, some of these are more predictive. So I'll summarise these. If we look at types of abuse, cases of neglect and previous abuse are more likely to result in future harm. We know children are more vulnerable to this happening again if they have developmental delay and special needs. We also know very young children who require rapid parental change are more vulnerable. With factors related to the parents, mental health features strongly. Likelihood of future harm is higher where there are certain types of personality disorder, combined mental illness and learning disability, paranoid psychosis, and any significant parental mental health problems. And then, when we look at family and social circumstances, higher likelihood where there is parental conflict and violence, situations of high stress, and lone parents where there is no family or social support networks.
Bruce. So some research-based indicators there. Anything else to note?
I mentioned the Ward Loughborough research paper. There's a lot more in the full document, of course. I just mentioned the most influential indicators. There are others. These only help your analysis. They will never be definite. Don't tick them off and believe you have a scientific prediction to hand. It's not that easy. Think of it as raising warning flags, so you pay good attention to it as you analyse likelihood. There has been some other research that has identified factors that give a better prognosis that a parent is likely to change. Some of the factors identified were the attitude of the family towards professionals, the degree of abuse that has taken place, whether parents are taking responsibility, and the balance between strengths and difficulties. So, a family with a good balance between strengths and difficulties has a more hopeful prognosis than families where they have considerable difficulties but only a few strengths. And to pick another one, if a parent fails to take any responsibility for the situation, it is less hopeful than for families where we hear the parents taking reasonable responsibility for the situation. How do we remember all this? I think there is a problem with research and case law. It's extensive. And even with the limited ideas presented here, it's a job to remember them when you need them. So what's most important to try to remember? Well, think about the difference between psychological harm and other types. What is your evidence that this may actually happen? How serious is the harm compared with how likely it is? How much responsibility is the parent taking? And what is their attitude towards professionals? And remember what research indicates, that abuse and neglect, parental mental illness, parental conflict and violence, all indicate abuse is more statistically likely to reoccur. Finally, likelihood is an important consideration. The burden of evidence is high, in particular if the likelihood is of emotional harm, which seems to be the highest indicated category of harm over recent years. I mentioned that likelihood is a prediction and is placed somewhere on a continuum. So there is no correct answer. It's the judgment. It's important that we evidence how we reach our judgment. Thank you.
Thanks, Bruce.